Homes for Fitness and Habitation Act 2018. Again, this is not a piece of new legislation, but the transition period was over on the 20th of March. So 3 days before we went into lockdown, we were all starting to panic. We knew it was coming. In fact, the 20th of March was the day the pubs closed. How sad is it that I know that? And it's also the day that the transition period ended for the Homes for Fitness and Habitation Act. For those of you that don't know, here is a very brief overview of what that act entails and what it means to you as a landlord. First and foremost, there's great news that it doesn't give you any new obligations as a landlord. So it's not going to cost you more money. It's not another certificate that you've got to have done. All it has done is the Landlord and Tenant Act has been amended to require properties, including the common areas, are fit for habitation at the beginning of a tenancy and throughout. So common areas now, I'm going to put this into two sectors. Bear this in mind, okay? Purpose-built flats. The common areas are the stairs, the landings, the communal space that people have to walk up and down. Outside, the paths to the building and so forth. And for HMO landlords, it's obviously going to involve the communal space within the HMO itself. You now have a legal obligation to ensure you did already, but you now have further legal obligations to make sure that the common areas are fit for habitation at the beginning of a tenancy and throughout. Okay, so at the beginning and throughout is the key here. So inspections are an absolute must. Otherwise, how will you know that the properties are being maintained throughout? You wouldn't. Okay, so let's just have a little, let's just continue. The Act, what the Act does is it provides additional means for the tenants to seek redress without going to the council. Guys, I hope you don't mind, but I'm going to put this in a nutshell. It gives the tenants the right to sue your ass. It genuinely gives the tenant the right to go straight to court and try and sue you for compensation or damages without the need for involving the council. That's probably the biggest concern about this piece of legislation. Hopefully I haven't frightened you to death, because there are requirements for them to do that, but I just want to make it clear that this is now a piece of legislation they can call upon without going to the council. Tenants can take action through the courts for breach of contract if the property is fit for habitation. Tenants, however, must try to resolve the matter before applying to the court. So if they have got a problem with something within the property, then they have to tell you about it and they have to allow you reasonable time to repair it. Now, the law states that they must do this in writing. Flip side to this, the law also states that you must respond to any maintenance requests in writing. So please bear that in mind. If you're responding to tenants' requests, it should be in writing and it should be saved somewhere. Who does this apply to? This applies to all tenancies that are shorter than 7 years, including assured short-hold tenancies, assured tenancies, and even social housing tenancies. So this applies across the board. And the question is, why for tenancies shorter less than 7 years? That's because any tenancies that are 7 years or more, actually repairing obligations become the onus of the tenant and not the landlord, including gas safety checks and so forth. But the tenancy needs to be 7 years on the contract, not the fact that they've lived there 7 years, renewing every year, just to be clear. Oh, I just got a little warning that we're nearly at the end, 15 minutes. Okay, so what exceptions are there? That you will not be required to remedy the fitness when the tenants cause the problem. You will not be required to remedy the problem if it's being caused by an event that's out of your control. So a fire, storm, flood, out of your control, pandemic, where the problem is caused by the tenant's own possession. So for example, if the tenant's installed a faulty appliance that's not belonging to you and that's caused a fire, that wouldn't be your situation to remedy. Whereby you haven't been able to gain consent for planning permission from freeholders, but you must have evidence that you've tried to obtain that. And where the tenant is not an individual, so i.e. a company let, anybody that's renting to a company, they do not have the rights to this piece of legislation to try and pursue you, and it doesn't apply to tenants under license to occupy. Timescales to carry out repairs. A landlord is responsible to carry out a repair from the moment that you're made aware of it. However, any hazard located in common parts of a block, particularly a block of flats, or a HMO, would make the landlord immediately liable. So as soon as there is a hazard in any communal part, you're liable whether you know or not. So it is essential that you carry out regular inspections and you make sure that those communal areas, where applicable, are checked and that they are documented on the inspection reports. Once you've identified that you are responsible for them, you then have a reasonable time to remedy the hazard. Now, landlords always say to me, Dawn, what's a reasonable time? Again, they like the word reasonable, but with no definition. So first and foremost, use your common sense. Try and remedy problems within a reasonable time scale and based on their urgency and severity. If you were sat at home and you had no hot water or heating, would you want that to be dealt with quickly? Absolutely, yes. One of the things that became an essential maintenance repair during the pandemic, believe it or not, was repair of a washing machine. And that was because of the cleaning of people's clothes, particularly if they were key workers. It actually became an essential repair. If a tenant tells you about a problem or you establish a problem in the communal spaces, particularly in blocks of flats where there's a freeholder, it's not your obligation to repair it, it's your obligation to notify the freeholder. So once you've done that with immediate effect, you've passed on that obligation. Might also be worth chasing it up. Remember that you should always provide 24 hours notice for a contractor to attend where possible. However, this is shorter if it's an emergency. The tenant must agree. Should a tenant fail to allow you access to carry out reported hazards, it's very important, again, that you document all of this so that you have evidence if the need occurs. I've just put a little action point at the bottom for you. When you are inspecting flats or buildings with communal areas, make sure that you make notes on the inspection for due diligence that all areas, including exterior, has been checked. Here is a list of what they look at to determine what is fit for habitation. I'm not going to read through them all because I think I'm going to eat into too much of the time, but you can see some of the things there. What you've got to bear in mind, guys, is that it is not necessary for a HHSRS assessment for the courts to determine that the property is unfit for habitation. So some of the big things here is damp, drainage, sanitation, supply of hot and cold water, the things that you would expect. So please pay particular attention to those. Now, I'm not saying if somebody's without hot water or heating that you have to repair it in 24 hours, because that's not always possible. Sometimes it might need a new boiler that might take 7 to 10 days. It's just making sure that you're carrying out the repair in a reasonable time scale. The penalties, in a nutshell, is the tenant can take you to court. They can be awarded compensation by ways of damages, currently unlimited, but will be determined on the perceived harm that has been inflicted on the tenant. Or the other penalty is an improvement order to carry out the work given by the court. And also, if you are taken to court and the tenant is successful, you're very likely to have to pay the tenant's legal costs.